Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. It is not uncommon for a single borrower to have two loans in default on different properties with the same lender. We'll use a recent appellate decision, Deutsche Bank v. Johnson, to discuss the topic of consolidation and when it's appropriate for two foreclosure matters to be consolidated. I'm Adam Friedman, managing partner at Friedman & Bartolo, and I'm joined today by Friedman & Bartolo counsel Megan McNamara and senior associate Hillary Prada. All right, ladies, thanks for joining me. You've both been on before. I'm very lucky to have both of you at the same time. Very excited. All right, so before we jump in, Megan, do you want to give us some background on the Johnson decision, specifically as it relates to the topic of consolidation?
Yeah, absolutely. So this was an appeal that was brought by the defendant, and he was seeking, among other things, to consolidate our junior action with the senior pending action. That was a 2007 action, I believe. Ours was 2020, so clearly very different, very different stages, but he was seeking to consolidate and to dismiss both actions.
Why not just seek to dismiss each case? Like, what was the benefit of consolidating and then dismissing both cases?
He knew that he wasn't going to win on dismissal, in my opinion. Like, the other case was already at judgment. He wasn't going to get the case dismissed. And our case was a newer action, but again, there was no basis to dismiss. So I think it was more of like, I think he sought the relief without realizing when he was actually seeking. I think the common goal was to delay.
Is there a rule in New York that covers consolidation, or is it something a judge is making a determination on a case-by-case basis?
Yeah, so this is governed by CPLR 602A, which says that when actions involving a common issue of law or fact are pending, the court may, upon motion, order a joint trial. And there are reasons why this would be granted or that would be denied. We actually specifically talk about this, look at HSBC versus Francis, which is a Second Department decision, and it talks about when consolidation should be granted. So that would help to avoid unnecessary delays, duplication of trials, save unnecessary costs and expenses, and it would prevent a potential injustice. However, there are cases where it would not make much sense. And that was when there's issues of common questions of law and fact are lacking. So not there. You don't have that privity of facts and law that go together. Additionally, actions that involve dissimilar issues or that could present a prejudice to the opposing party.
Let's talk about this as if we're not lawyers for a second. So, like, what does that mean? Like, when we say like a question of law or fact, because, I mean, facts are concrete things. They're also somewhat, not abstract, but like, you could see how a lot of cases could be connected. When we're thinking about it in our world of foreclosure or just like property more generally, like, what are we looking for? Is it like different properties, different loans? Like, what would you think would make it where two cases are connected or are not connected?
So there are certain details that you could look for to have those similarities. So, for example, if you have the same property or the same loan or the same parties, that doesn't always mean that you would have the common issues of law and fact, but at least that's a basis to start, where you can say, okay, at least we have that commonality, and I can look closer at those details and see if then I have further commonality.
Right. So I'm not trying to get you to like give like a definitive answer on this, but really, like, if it's not the same loan and it's not the same property, then it's probably, I don't want to say impossible, but it's probably impossible for the cases to be connected. Would that be fair to say?
It's fairly unlikely, and that would be our argument. Mm-hmm. So in this case, for our set of facts, we had two different lenders, we had two different dates of default, we had two different completely loans. They were at completely different stages of the action. So our position was it would make absolutely no sense to consolidate these cases. There is a situation in which there is Second Department case law saying that it would make sense. It's a little bit different than the two loans that we have here. It's where there's an allegation of a fraudulent conveyance and an underlying mortgage foreclosure action. So the defendant is saying, these two actions are intrinsically connected, and it would be an injustice to not try them together. So I have seen Second Department case law in which it has been determined that that would be appropriate to consolidate those actions.
Okay, and then in this situation, you're saying it was the same property. It was the first and the second mortgage.
Exactly.
Correct.
And that was the only real commonality between the two actions.
Both loans were taken out the same day, but they had been assigned to different parties, so there was different holders of the note, completely different plaintiffs, different dates of default, and like I said, different stages. One was at judgment, or past judgment, I believe, and our case was randomly commenced.
It's interesting because I think to a lay individual, you would think same borrower, same lender, same property. These are connected. But really, when you think about it, especially when you're dealing with a mortgage foreclosure, the real key is the loan. and they're different loans.
And the proof, how you're going to prove it. So our way of proving it is going to be completely different than how the other side is going to, for their loan, prove it. So I think that's kind of where it hinged on for us. And it is interesting because exactly right, Adam, like from like a layperson's perspective, well, why wouldn't you just try them together? Because it is ultimately foreclosure for the same property. But ultimately, like it rests on, in this case, the proof would be different, how to prove the different allegations.
And even how you go about proving what's due and owing. You're dealing with different loans, with different dates of default, with different payment histories, with different expenses that each plaintiff has levied for the property. So it's very, very complicated.
Why would this defendant or any defendant want to consolidate? Just to get the easy answer out is that they don't want to waste their time or money either, right? But in this situation, because they're defending against two different really unrelated claims, like they have to realize that they defaulted on two totally different loans, right? So I guess you could say, well, maybe it's nicer to go to one trial as opposed to two. But like, was there a strategy in trying to consolidate?
I think it was delay, perhaps. I think there was maybe a delay strategy there. I could understand why, if you're raising the same sort of boilerplate defenses, you're trying to get both sides to, prove their burden. I think that could be a basis for it. Where we would see it as being beneficial is if you have the same lender, first and second lien. So one of the things that we do here, which again is slightly different, but we would proactively raise that in one action. So we would commence as a first and second cause of action where, it has to be a commonality. There has to be no intervening liens, same lender. But our firm is looking at that, and it really, in those situations, so kind of similar topic, but a little bit different. And we're proactively saying, like, these events are similar. They should be tried together as a first and second cause of action. Our firm is doing that, although it's not super widespread, I would say.
If we're talking about foreclosure actions, we're saying it might be appropriate to consolidate if we're dealing with the same loan and the same default or same way we're going to have to prove a default. Is that fair to say?
Yes, and in the situation where we mentioned before where there is like an allegation of fraudulent conveyance and there is a kind of similar issue there where you're tying in where you need to prove one action in order to prove the second. So that would be slightly different, but that would be a circumstance where I would say it would be considered potentially appropriate.
So, like, for example, if you have a deed transfer and then a bona fide purchaser who's now and then you have someone trying to invalidate that deed.
Yes.
To recap, in New York, CPLR 602A governs consolidation, and it states that where two actions involve a common question of law or fact, a court may order the actions be consolidated to avoid unnecessary costs or delays. In the Johnson matter, the consolidation motion was denied because the two actions, while concerning the same borrower and lender, focused on unrelated loans and defaults. Thank you for joining Hillary Prada, Megan McNamara, and I on the Weekly Friedman, your source of the most essential information in the default industry. Looking forward to seeing you next time, and thanks for tuning in.